Good evening and welcome. This is the May 24th, 2023 public hearing of the Land Use Commission. The City Code directs this body to hear applications for map and text amendments, special uses including plan developments, zoning relief, and appeals from decisions of the zoning administrator, as well as to make recommendations regarding the city's long-term planning goals and objectives. Depending on the type of matter, this commission will either make a final determination or send its recommendation to City Council. Ms. Ashbaugh, would you please call the roll?
Commissioner Lindwall,
Here.
Commissioner Johnson,
Here.
Commissioner Miranchev,
Here.
Commissioner Pucktell is absent, Commissioner Halleck is absent, Commissioner Hugo is absent, Commissioner Aravallo,
Here.
and Chair Rogers.
Here, with 6 members present,
Okay, Ms. Westerberg.
Here.
Commissioner Westerberg.
Sorry. Now it's 6. With 6 members present, we do have a quorum. Also present tonight from city staff are planner Katie Ashbaugh, zoning administrator Melissa Klotz, planning manager Liz Williams, and assistant city attorney Brian George. This is a formal hearing, and there are rules that govern our proceedings. Most importantly, only one person speaks at a time so that all testimony may be accurately recorded. Anyone who wishes to address the commission regarding any matter on tonight's agenda will have the opportunity to do so at the appropriate time. Our procedure is to hear from staff on the documents on file and then receive testimony and other evidence from the applicant or appellant. After that, persons wishing to make a statement regarding the matter will have a chance to do so. Any person with a legal interest in property located within the defined notification requirements of the subject property may present evidence, reasonably question witnesses, or seek a continuance of the hearing. When all supporting and opposing testimony and statements have been heard, the applicant or appellant will be given the opportunity for rebuttal or a closing statement. Then the commission will close the record and begin deliberations to consider the standards. The commission will make formal findings of fact based on the testimony and evidence presented, guided by the standards, the commissioner's knowledge of the community, and the recommendations of staff. All testimony is taken under oath. Although we do not apply the strict rules of evidence, please limit your testimony to the proposal as it relates to the standards contained in the zoning ordinance and the corresponding staff memorandum. When testifying, please state your name and address for the record and sign in on the provided public comment sheet. Our meetings are audio and video recorded. Please make sure that you are at a microphone when asking questions or making statements so that you can be properly recorded. All proceedings are subject to broadcast at a later date. Any matter not concluded at tonight's hearing will be continued to our next regularly scheduled meeting. On tonight's agenda, we do have 3 items in new business. The first one is 831 Foster Street, and I'm just going to take attendance. Is the applicant here? Thank you. 1806 through 1808 Dempster Street, applicant is here. And the last one is actually a city omnibus, so we're here. With that, I'm going to move to the first item on our agenda, which is approval of the meeting minutes for May 10th, 2023. Has everyone had a chance to read through those? And is there a motion to approve?
I move to approve the May 10th minutes.
Moved by Commissioner Lindwall. Is there a second?
I'll second.
Second by Commissioner Westerberg. Is there any further discussion, any corrections, edits? Hearing none. All those in favor, please say aye.
Aye.
Any opposed? And does anyone have to abstain? I was going to say Commissioner Johnson will be abstaining because he was not at that meeting. So the motion carries and those minutes are approved. With that, we will move into the first case on tonight's agenda, which is 831 Foster Street, and I would ask that that be read into the record, please.
Mohammed Abdelmajid Lassi requests a special use permit for a convenience store to sell food, beverages, household goods, and tobacco in the B1 Business District under City Code Section 6923. The Land Use Commission makes a recommendation to the City Council, the determining body for this case per City Code Section 6358. This is zoning case 23ZMJV-0026. And is a public hearing for a special use at 831 Foster Street.
Thank you. With that, the chair will open the public testimony into this case regarding 831 Foster Street. And I'll ask that anyone who may be speaking to us tonight on this matter, please be sworn at this time by raising your right hand. You can all just do it from your seat if anybody's going to give testimony. Do you swear or affirm to tell the truth throughout the course of these proceedings? Thank you. Now you can come on up, and if you'd introduce yourself to us, please.
Hey, my name is Mohammed Abdel Majid. I'm looking to open a convenience store at 831 Foster Street. I thought it was, a great location for the students and the community right by the Foster train station, and thought that it would be a good spot for our business.
Do commissioners have questions?
Yeah, I have one, or maybe two. With respect to, you indicated that you're intending to sell deli items
Yes.
and cold sandwiches. Could you describe kind of how that operation will work? Or are they prepackaged sandwiches, or are you slicing the meats there?
Yeah, so the meats are gonna, so all the deli meats are placed into a deli fridge. And really, we're gonna slice it based off of, customer demand. So let's say a customer orders a pastrami sandwich, we'll pull out the meat, put it in the slicer, slice it up, and, make it fresh for customers rather than like prepackaged items. So it's gonna be,
A regular
made
deli.
fresh. Yeah.
And then, I guess, well, this is not necessarily a zoning issue. Have you been in contact with the health department to see about what kinds of food service certifications are required?
Yeah, I haven't got the chance to, I did speak with, I believe it was Melissa, sorry, yeah. I'm not-
Ellen Golden?
Ellen, yeah, I did speak with Ellen. I just haven't followed through the whole process yet with the health application stuff. I'm not at that step as of yet.
Okay, but you intend to follow all of the?
Yeah, definitely, absolutely.
Thank you.
Commissioner Westerberg?
Do you have other stores like this anywhere else? Or how long have you been doing this type of thing?
Yeah, so I've actually brought my family members today, and we've been doing this for almost like 10 years. One of the closest ones we have in the north side of Chicago is Hollywood Deli, right off of Lakeshore Drive. So it's Sheridan and Hollywood Avenue, and we've had that store for about 5 years. So.
How large does the footprint allow you to have sort of a separate area for preparing the cold cuts, the fresh foods? I'm not so concerned with what's packaged, but anything that is not packaged. Can you kind of describe how that will be set up?
The only thing that won't be packaged would probably be the toppings. So like those, we're gonna have like a salad table where we're gonna have like the ingredients set out, but everything has like an expiration date and whatnot. But yeah, I would say the salad table is the only thing that's gonna be opened.
So if you look at this floor plan, can you identify where that would be on the floor plan?
Yeah, so if you go by the deli counter, yeah, so that's a 3-compartment sink right to the right, a little to the right. Yeah, so that's gonna be where the deli fridge is, as well as the salad prep table. So that's where we're gonna be making the sandwiches. So there's gonna be, a hand wash sink right behind, the salad table. So, prior and before we prepare any sandwiches, we had the sink right behind us.
Thank you.
How are you going to dispose your waste?
Can you explain that a
Do
bit
you
further?
have garbage cans? Do you have containers? How will you get out of food waste?
Yeah, inside the store or outside? Sorry.
From the store,
From the store.
outside to the
Yeah.
truck, and
Sure. Yeah, so, yeah, I mean, we do plan on having disposable bins, obviously behind the deli counter. And then there is a hallway that leads to the back where we have the option to both recycle as well as, put it in, the regular garbage bin and whatnot. I believe we have 3 garbage cans, and the garbage truck comes twice a week. I believe it was Tuesday and Friday. But yeah,
is there a door
yes,
to
there
the
is.
rear?
Yes, there is a back door.
Because I didn't see it, that's why I'm asking all these questions.
Yep. Yeah. So, actually, in the back of 831 Foster Deli, in the rear, here, maybe if you pull up the floor plan, I can show you. So there is a. Oops. Yeah, as you could see, there's an exit door over there, and that hallway actually leads to the back, in the top middle.
I really don't see it, that's why I'm asking all these questions. I don't see the exit door.
Okay.
Can you zoom in?
It's at the top there, it's handwritten
Top
in with
left.
The
big
Oh, it's
black
exit,
box on the
I
top.
read something else.
Yeah.
Yep.
Okay, so this leads to an empty space where you
Yes.
can put your garbage cans?
Yes.
Okay. And you know that we have relatively strict regulation about rats and other things. Are you prepared to do that?
Yeah, definitely. I believe we have a good amount of resources to, make sure that we have a healthy and clean environment. Like I said, the landlord gave us 3 garbage bins, as well as, the garbage truck is going to be coming twice a week, so we should be prepared for that.
And the garbage truck can go to the exit door over there. Is
Correct.
that correct?
Yes.
Okay, thank you.
Another question, Commissioner Johnson?
Do you anticipate most of your customers arriving by foot or by train rather than driving?
Yeah, absolutely. We're counting on both, foot traffic as well as, students or community members from the Foster train station.
Thank you.
Yep, no problem.
I have just some simple questions. Most of these are in the application. I just kind of want to get them on the record so
Sure.
we have them recorded. What are your planned hours of operation?
I believe we have it down as 7:30 to 8:30.
Okay,
I think it's 8 o'clock.
yeah.
Oh, to 8. Okay, sorry.
Question for staff is, do we have sort of, I know in the downtown area, sometimes we have sort of our general outlying hours that we usually give.
Typically in the past has been until 11 p.m. weekdays and midnight weekends,
Okay, and do we have a starting time that we usually put in?
usually 6 a.m.
That's what I thought. Okay. How many employees will you have working in the store at any one time?
So it'll only be 2 employees, one working at the front register and then one working in the deli.
Okay.
Yeah.
What type of deliveries are you anticipating, and how will those be handled in terms of like getting your supplies, your vendors?
Yeah, so, it'll probably be like soft drinks, snacks, yeah, mostly just like drinks and like snacks, chips, grocery items. That's gonna be the stuff that we restock the heaviest.
And what size delivery trucks is kind of what I'm getting at here? Are you anticipating vans, kind of the small box trucks? I'm assuming there's no semis involved.
Yeah, yeah, definitely not any semis. It's mostly gonna be like vans and small box trucks, yeah.
And where will they be making those deliveries? Will they be doing those through the back of the building?
Yeah, through the rear,
Okay.
yes.
And then you are aware of the, because tobacco is one of the items that you have listed, and so the city has made you aware that obviously we have a prohibition on you selling more than 50% of your sales.
Yep.
Turning you into a tobacco shop. So just wanted
Sure.
to make sure you're aware of that.
Yes.
And then there was a little bit of discussion on trash and litter. You are aware of the city's litter collection plan that says you're responsible for sort of policing within 250 feet of your property and making sure that any trash is picked up, whether it's yours or someone else's.
Absolutely.
All right. And there were some department recommendations that were put in the paperwork that was handed to us, which were the cashier being at the front of the store, the tobacco sales, which we've already talked about, storefront window obstructions, making sure that there's trash near the cashier so it's accessible to customers, and the litter collection plan we talked about, and you're fine with all
Yep.
of those.
Absolutely. And as stated on here, the front register is already placed in the front. So we have that. And then I did label the tobacco. It was only going to be behind the counter. And then, yeah, we'll, I'll put a label for, the disposable bin towards the front as well.
All right. Any other questions from commissioners? All right. Is there anybody else who wishes to speak to us on this matter? I'm not seeing anyone. So anything you'd like to say in summation before we close the record and begin deliberation?
Yeah, I only had one question.
Sure.
So if you can actually pull up what we were just looking at. So our bathrooms so we have bathrooms already in place. I'm sort of curious if we need to make any modifications for the city of Evanston. We do have, a sink as soon as you exit the bathroom. The only thing is this was previously used by a preschool, so the toilets are low. We do plan on replacing them. And then the doors were cut in half because, they wanted to monitor the kids.
Right.
So we do plan on replacing the toilet, making, putting a standard size toilet as well as a full size door. And the bathrooms aren't going to be open to the public, so it's only going to be used by the employees. But I wanted to ensure that, we can keep the same bathrooms.
I'm going to let
right
staff
now.
answer that because that's more of
Sure.
a building.
You'll need to consult with an architect on it. It ultimately depends on the plumbing code and the occupancy of the space, but you may need an ADA restroom. So
Okay.
definitely consult with an architect on that. And if you do, then you'll need to submit architectural plans for a building permit for it.
Okay, thank you.
All right. Anything else you'd like to?
That would be it. Thank you for your
All right.
time.
Thank you. With that, we'll close the public testimony and move into the deliberation. I'm getting a general sense from the commission that there's not a lot of concerns here. Is there anything that someone feels should be maybe made a condition that we've missed? Typically, when we do these sorts of things, we do the hours. No employee parking on the street, the deliveries coming in through the rear, and adherence to the litter collection plan. The 50% tobacco thing, which I ran through, isn't really one of our standard things, but that's more of a something specific to this particular project. Anything else? Commissioner Westerberg?
I'm assuming, obviously, any store like this has to follow all of the city health
Right.
requirements, so I don't know that that needs to be placed in if we feel it needs to be
That kind of
emphasized.
falls under our standard number 9, which covers off on any other applicable ordinances for the use in the city.
Yeah, I mean, it's just a matter of, should we have a condition that says you need to comply with the health department regulations? as a
mean,
condition.
we-
I mean, then
we can
obvious.
put it, we can put it in.
I
like
mean,
said,
then
it's kind of
obviously,
implied, but-
then obviously 9 would be met.
Yeah.
If I may, Chair and Commission members, we do have a standard condition that staff usually always adds to every ordinance that you are recommending on, that all other applicable local, state, federal law applies, and they have to comply.
So we don't need to add that ourselves.
No, it'll go in there.
All right. Anything from this side? Okay. There are 9 standards that we must find are met. Again, we are recommending body in this particular case, making a recommendation onto city council. And so we will run through those 9 standards. The first standard being it is one of the special uses specifically listed in the zoning ordinance. In a B1 business district, we do find that a store similar to this is permitted, a convenience store, and so that standard is met. Number 2, it is in keeping with the purposes and policies of the adapted comprehensive general plan, and the zoning ordinance is amended from time to time. The comprehensive general plan does encourage for development in our business districts. Our B districts are slightly smaller, more neighborhood-oriented business districts as opposed to commercial and downtown. So finding a business that would make use of a business space does make sense and does meet that standard. Number 3, it will not cause a negative cumulative effect when considered in conjunction with the cumulative effect of various special uses of all types on the immediate neighborhood. This standard, I believe, is met. The impact of this store should be minimal. We've had a little bit of discussion about most of this will be foot traffic, so we don't expect to have problems with traffic on the street. And the overall impact of a storefront that's about 1,100 square feet that's selling convenience type items and deli type items shouldn't tax the neighborhood. So I believe that standard is met. Number 4, it does not interfere with or diminish the value of property in the neighborhood. Obviously, having a functioning business in a storefront always does more for property values than having an empty storefront. We haven't heard anybody showing up here testifying that we should be concerned about anything in particular, so I believe that standard is met. Number 5, it can be adequately served by public facilities and services. The building is not going to see a drastic increase from previous uses. We heard testimony that it was a daycare, a day school at one point, but this is not something that we really should be concerned about taxing, again, the facilities and services. Number 6, it does not cause undue traffic congestion. I'll kind of reiterate what I said a little earlier, that we are anticipating most of the traffic for this to be pedestrian traffic, bicyclists, people going to and from the train. So I believe that is fine. Number 7, it preserves significant historical and architectural resources. Although I don't know that there are any for this particular building, we're not looking at changing the outside of the building, so that standard is met. Number 8, it preserves significant natural and environmental features. Again, without any changes to the exterior of the building, that standard is met. And number 9, it complies with all other applicable regulations of the district in which it is located and other applicable ordinances, except to the extent which those have been modified through plan developments or grant of variation. We did have a little bit of discussion just a moment ago about obviously serving food. You will be required to get licensing through the health department, and they will constantly monitor your operations. So that would be one of the few things that would be unique in this particular area. So that standard is met. Is everyone in agreement with my finding on standards? With that, and keeping in mind those conditions that we've sort of talked about earlier, both in the staff recommendations 1 through 5, as well as the hours of operation between 6 and 11.
Yeah, that's fine.
Yeah, and those are, you don't have to operate during those hours. It's just, if all of a sudden you wanted to stay open till 9 o'clock, you don't have to come back and ask for permission again. If you wanted to suddenly open up at 6 o'clock to try to catch more morning traffic, you don't have to come back and ask for additional. So 6 to 11 and 6 to 12, which tends to be sort of the downtown hours that we keep for businesses. deliveries being made in the rear, and adherence to the litter collection plan. Is there a motion to recommend approval for this?
Sure. I move that the Land Use Commission recommend approval of the special use 23ZMJV-0026 at 831 Foster Street for a convenience store to the city council, subject to, do you want me to read the conditions, or can we?
I would go ahead and put them in just briefly so that we make sure that
Okay.
they're all.
All right, subject to the conditions that the cashier is located at the front of the store, that tobacco sales are not to exceed 50% of total sales or floor display, that storefront window obstruction is restricted to a height of 3 feet above grade, that a refuse receptacle be placed near the cashier and is to be accessible to customers. The store owner will clean up litter within 250 feet of the front of the store. Number 6, that that employees will not park on the street. And 7, that the hours of operation be limited to between 6 a.m. and 11 p.m. on Sunday through Thursday, and 6 a.m. to midnight on Friday and Saturday.
It's been moved. Is there a second?
I'll second.
Been moved by Commissioner Lindwall and seconded by Commissioner Westerberg. Is there any further discussion? Hearing none, would you please call the roll?
Commissioner Lindwall,
Yes?
Commissioner Johnson, Commissioner Westerberg,
Yes.
Commissioner Miranchev,
Yes.
Commissioner Aravallo,
Yes.
Chair Rogers.
Yes. So with 6 votes in favor, the motion carries, and you will move forward to City Council with a recommendation for approval. Good luck with your project, and city staff will tell you what you need to do next in terms of moving forward with City Council. Thank you. With that, we will move on to the second case that we have this evening, which is 1806 through 1808 Dempster Street, 23 ZMJV 0028. Is this, Ms. Klotz, is this you? Would you please read it into the record?
Danielle Dean, lessee, requests special use permits for 2 independent businesses, an existing convenience store at 1806 Dempster Street, Dempster Snack Shop, currently in operation with approved special use ordinance 120-021, and a new Type 2 restaurant at 1808 Dempster Street, Windy City Flavors, in the B1 Business District, City Code Sections 6922.5 and 6923. The Land Use Commission makes a recommendation to the City Council, the determining body for this case per City Code Section 6358. In addition, some information was sent out to commissioners this afternoon, just to make sure that everybody did review that. And the applicant also has a copy of that.
Yes. Okay. I'm going to ask you to please be sworn in. I don't know if you'll be speaking as well, but if you just raise your hand, do you swear or affirm to tell the truth throughout the course of these proceedings?
Yes, I do.
Thank you very much. At this point, the chair will go ahead and open up public testimony on 23 ZMJV 0028. If you begin by introducing yourself.
I'm Danielle Dean, owner of Windy City Fitness Club, Dempster Snack Shop, and trying to do Windy City Flavors.
All right. And if you'd please tell us about your proposal.
I'm trying to really do like salads, nachos, hot dogs, things. First, I want to tell y'all guys, so I got the pictures and stuff too, I want to take accountability for my actions and whatever I could do to right my actions. That's what I want to try to do. But I got a lot going on my plate. So I've been doing the fitness thing for 11 years. I was in Skokie for 7 years, been on Howard Street for like 4, which we're also moving over to Dempster. I don't know where to really start at, but trying to do hot dogs, nachos, things the way I've been trying to do that for like over a year now. So the space next door came available, so we talked to the landlord and was able to get it.
So you currently are operating
Dempster Snack Shop.
Dempster Snack Shop. You're looking to expand
Yes, next door.
next door with Windy City Flavors.
Yeah, so, well, to stop y'all, well, what ended up happening with that, when we first got 1806, we was trying to sell nachos, things of that nature. So what ended up happening was we had talked to an architect, we had a plumber, to where somehow that our paperwork got mixed up. When we got 1808, our paperwork got mixed up with 1806. So the things that they was looking for us to have in 1806 was in 1808. So our paperwork had been sitting on the desk since November. Melissa had looked at it and found out what was going on. I ended up coming in, which has been like months. So I was really like wondering what's going on. So I came in to find out what's going on, and this is how we're here now.
Okay. All right. One of the things that we kind of have to address that you've kind of hit on already is we got notice today that you have been cited by the health department.
Yeah,
for
that's
some
why I told you I take accountability
Right,
for all
right.
my actions. I'm here to,
Right.
whatever we need, whatever I need to do on my end to fix it,
Right.
you know, let's get this right.
Okay. I'm going to run through just some of the basic questions that you just heard me ask the last applicant because they're going to be kind of the same things. So what are your proposed hours of operation for the new site?
It'll probably be like 11 to 7, or no later than like 9 o'clock. And then on the weekends, I want to probably say probably like 11. I think this, Melissa was explaining we can close at 12.
Is that,
I'm sorry, can you repeat that?
closing time on weekends?
Asking about the closing operation hours.
Yes, I mean, typical in any of the business district areas.
So we don't care whether it's a B or a C or
We do not.
downtown? Okay. All right. All right. How many employees do you anticipate having at each of the
So
different?
really pretty much one, because it's not like a lot.
So the stores will be combined internally?
This is what I'm trying to like, with dealing with y'all, trying to figure it out, how should I do it the right way? Because it's like I don't want to take away from either or. And then like I told you, I have a fitness studio that we be putting at 1803. I just finished filling out some paperwork for the fire department to come and inspect that. We just got all the equipment moved over there. So I just felt like, probably because I deal with like a lot of people. I've helped a lot of people in my community. I have helped a lot of people, like a lot. So I'm trying to find a way to where I could still keep things going, to where I can even offer this and offer that, and the kids, everybody happy,
Okay.
type of thing.
In terms of deliveries, what types of deliveries are you anticipating?
Right now, at this moment, I don't really see no delivery. I just, pretty much in and out.
No, I'm sorry. So in terms of deliveries, it's the stuff that's coming to you.
Oh, the stuff.
So
that
your
we
vendor-
not-
your
yeah,
vendors that are providing
Yeah,
you.
our vendors, we pretty much go to Sam's Club, things like that. Those is like things that we can move ourselves.
Okay,
It's
so
not
you-
like we got like a big old space.
Yeah, so you
Yeah.
aren't getting trucks coming
Nah,
in
no
with
trucks, no trucks.
delivery sorts of things? Okay.
It's pretty much the stuff, the same things that we have at the snack shop, but the only difference is we probably had the nachos, the hot dogs, and some popcorn. So this was my original proposal. So like going through this, it like kind of had me all over the place. You get what I'm saying? Because it was like we was told this. So now that we get this, then it was like another process to where, yeah, I did get a little frustrated. It happens, you know, because I'm still, like I want to explain to Melissa and explain to y'all too, I'm still paying rent. So with my finding out that my application had been sitting since November, my rent is still going.
Right.
It literally drained me. You know, so it forced my hand to do some things out of line, which I will take accountability to. But, and again, whatever we need to do to fix that, I'm with that. But that's my situation. Like, the rent don't stop. So it's like you can have a dream, you give it, once you sign a lease with these landlords, now it's a whole nother process. It's draining. Then to find out, again, my paperwork been sitting since November. You know, I wasn't contacted. Which we probably wouldn't be here right now if I didn't come up here.
Okay. So it looks like in the new space, do you plan on having like any place for people to sit down, or is this strictly?
Everything is strictly in and out. So it's like, I don't know, I just, like I say, Dempster, I feel like we have brought a lot of life to Dempster. If y'all from Evanston, y'all familiar with Evanston, right? So y'all know, I know Dempster has been very, very quiet. So I'm even looking at some of this paperwork that's in here. Now, some of the violations that we have, I take accountability to. But it's also like some racist things in here that I feel in my heart, and I hate to say that, but it is what it is. Because I'm looking at a complaint to which I know for a fact that the lady that we got the space from, she did a lot of things to try to blackball us. So if you pay attention to if you look at the complaint that's on there, for one, as long as we've been open over there ain't been no shootings, there haven't been no fights, there haven't been no police calls, so that make me feel like it's a black thing. You understand what I'm saying to you? Because I only see one person in there complaining, and then I know that we had a situation with Yvette Cameron, which is a whole nother story. I was able to explain something to Melissa. If she can, you probably fill y'all in on that. But it was just like a whole mix-up thing. So like a gym is something that I'm very good at with opening, knowing what the procedures are. This I was new to. And did I get a little rattled? Yes.
All right. Other questions from other commissioners?
So, quick question. The two stores are side by side, but there's no interior connection between the two, right?
No. So that's
Just
why,
those outside doors.
Yeah, that's why we went with the
So,
second name.
first question is, can you really have one person, you're going to have one person in each store, correct?
Yeah, it's one person in each store, yeah.
Okay. So what will happen if they need to take a break? You know, I'm a little worried about the staffing, I guess. That's kind of what I'm
I
asking.
mean, with the staffing, I mean, you would have to be worried about the staffing, you would probably have to come over there and see what's going on for yourself. So it's not
I took
like.
a look today, and I know there's small stores.
Yeah,
It's just-
so
it's
it's
just
not
more.
like, it's not like nothing major, and then it's like, I mean, it's somebody pretty much on hand at all time. So like, as far as with a break, we pretty much dealing with family right now. So I haven't got to that step yet, let me put it to you like that. So like right now, I've just been working my behind off and doing what it does it take, so I haven't had a chance to even take a break.
Okay, understood.
So I plan to be more hands-in right now, at least for the first year.
All right. Talk a little bit, the idea is to keep sales within the stores and not have anything outside in the sidewalk, correct?
Yes.
I know you've had some issues in the past with that, but from what you said in your emails, I understand you realize that can't be grilling outdoors, anything like that,
That's
right?
why I told you I take accountability of everything, and whatever we need to do to fix that moving forward, that's what I'm here to do.
Okay. Now, the 3-sink is already installed?
Yeah,
in the new one?
everything was over there, so that was like, so it was like, you know, when you got a dream, you're like, okay, well, I got this, then you find out you got that. So when we did see that next door, that's where we was able to stop the process what we was finna do with the 1806, and the paperwork ended up getting mixed up. So it's like everything that they asked us to have at 1806, it was next door. So it's not like we was really trying to do like a whole major thing. We really just been trying to sell some nachos and hot dogs. In all honesty, so then when the fitness thing came too, I figured throw a few salads in, things of that nature. You know what I'm saying? So that's
Oh, I
pretty much.
understand. You know, they say, if you ever want to raise your blood pressure, open up a food shop, and there it goes. So,
Trust me, I get it.
understood.
So all of the salads and nachos and hot dogs would all be produced and sold at 1808?
Yes, ma'am.
That's correct?
Yes, ma'am.
And just looking on the plan, it looks like there are 5 counter seats on your plan.
No, so that was the first one. I think the first plan that he might have sent in to you guys, that's when they let us know that we can't, with the size space that we have, that we can't
Do
have the
any.
dine-in. So that's why I
Okay.
say we in and out.
So that's just, all right. And then I guess the other thing, in some of your descriptions, you talked about selling Polish.
Yeah, so
So how do you plan on cooking the Polish?
they got hot dog rollers. They got food warmers.
Yeah, so they'll just be warmed. They won't be
Yeah,
grilled, they won't be deep
hot dog
fried.
take 5 minutes to cook, bro.
Yeah, well, hot
Then
dogs.
you know they
hot
got the
dog-
hot.
hot
You seen the
dogs-
hot dog warmers at 7-Eleven?
Oh, no, I get the hot dog warmers.
you asked me how I was cooking it, so I explained it to
it's
you.
just I usually have always had Polishes that have either been grilled or deep fried.
Nah, they got, so you never had the Chicago dog where they went in the warmer and picked it up and put it on
Oh,
the
of
bun
course
for
I
you?
have.
Okay, that's how we gonna sell them.
For the applicant? I'll ask if there's anybody else here who wants to speak, but I think the only other person here is with you. So is there anything you'd like to say in summation before we?
I mean, no, not really. I mean, yes, I am gonna say something. So like, I kind of felt like, I'm not gonna say I was violated, but like when Kylie walked in the other day, it wasn't what she was looking at. I'm not gonna say what I haven't done in the past because it's like, so it's like I got a place of business. We still sell pops, chips and stuff next door. So sometimes we stack that stuff next door too, because if we run out, we can still run next door. So I just kind of felt like, I don't know, I'm not gonna say targeted because she been cool, but it's just still, I just felt like she didn't really get my consent to come in. We're not open to the public. I'm not going to knock nothing, but I don't know. I just kind of felt because she was coming to look at 1806, just the way that she came and bothered me, and then she lied. She told me she was going to send a picture, but she was supposed to come and take more pictures as well, which she did not do. You understand? So it's just like I just kind of felt like my little personal space was kind of invaded, and it made it look like something more than what it is. I'm not going to say what I haven't done in the past, but in all honesty, that day I'm just in the process of, so it's like having a place. I mean, I'm for sure some of y'all know when you got a dream or a vision or whatsoever, you get a commercial space in order to know where you're going to put things already. If you look at even the drawings that the architect sent in, everything is kind of put up in play. So it's like, even with us not open, you still might want to see what our vision look like, or if we need to move something, or does this fit right there? You understand what I'm saying to you? So without like messing with it, how do I know? You understand what I'm saying to you?
Right.
And then if you look in there and if you look on the paper, you're going to see mostly pops and chips, man.
I do have another question. Are you going to go through and get the food service certification?
Yeah, I'm gonna do that, yeah.
But
Yeah.
I think, and I'm
I-
not positive,
yeah.
I think each of your employees.
Yeah, I'm
probably-
going to do that, but like right now, I'm just, like I say, I'm so overwhelmed. I'm just taking one step at a time. So like as far as I'm about to be the head honcho right now. This is something that I told myself. So I will have everything that's needed. And that's,
So out of the, because one of the conditions that we have to find is, standards that we have to find is met, that you're in compliance with things.
yeah, that's why I'm
So, and I appreciate you coming, you're taking ownership, responsibility and saying, yeah. What type of a timeline do you think you need to bring yourself into compliance with those things?
I mean, and I don't know what you guys, so it's like even right now, I just really want to know what do you guys want? Because it's like, y'all could tell us something. I don't know. I'm new to it, so I'm trying to find out what do y'all want. What should I do? So like for instance, with Dempster Snack Shop, y'all told us to get a bike rack. Don't nobody even use the bike rack, and I don't see no other stores with a bike rack. So it's like, not pointing no fingers, but it's like, come on.
Right.
But I don't know what's needed unless y'all tell me. I'm here to learn from y'all.
Well, and you're dealing with we're one very small part of
Yeah,
this.
so I'm just.
So the health department things are outside of us, but we pay attention to what they're doing.
I mean, we
And-
supposed to, and it's a like I said, it's a learning process for me. So I'm sucking it all up, and I'm learning as well.
So I guess my question to you is to sort of figure out what type of time you need to get things in order so that we could recommend approval of this. Because right now, I can't recommend approval of this if you're not in compliance with the health codes.
Okay, so as far as with the health codes compliance, Carly pretty much told me what to do. So what I'm asking you guys is, what do you need? What else? As far as with me getting ready, I could tell you I could be ready next week. You understand what I'm saying to you?
So
might have-
you think you can address everything, and I'm sorry,
I don't know what needs to be addressed. This is why I'm asking.
Well, I don't know what needs to be addressed either. That's
So
through the
let's
health
talk about it.
department. That's through the health department, and the
Yeah,
health
so
department isn't
I
here.
can't tell you what time frame if I don't know when I'm looking at it, what needs to be done. Understand what I'm saying?
I do, but you probably have more paperwork on this than I do.
It's not, I mean, as far as with my blueprint and things, I could,
No, I'm saying in terms of the health issues. That's the thing I want to do. Because I cannot find that the standard is met, that you will comply with all the other regulations and the health code if you are currently not in compliance.
I respect that. So
And
that's
so
why
what I want to do is, I don't want to have to deny you.
No, I get it.
I want to be able to work with you.
Yeah, no, I respect that. That's
And
what
I
I'm
want
saying.
you to tell me what type of time you need.
I mean, give me
because-
30, 45 days and I could be ready.
So I guess the question is, if we were to put through a recommendation, or we can continue.
Yeah, just, listen.
You could do either. I would suggest that either way, you set a number of perhaps unscheduled health department inspections so that they can confirm that everything is within compliance, likely more than once.
I mean, this isn't really within our purview, but can we ask for an update at our next meeting from the health department? I mean, I can't tell the health department what to do, what not to do. But is that something that staff would feel comfortable asking a courtesy of the health department to sort of check in?
Yes, so they would need to do another inspection, and to clarify, most of the violations that were found were because you do not yet have this approval or
No, I
the health department approval to have the unpackaged food. So all of that would
Yeah.
need to stop and
Yeah,
to
I probably,
resolve all
you
of
guys
those
have my word of
violations.
that. So that's why I'm here to take accountability on that. I want to take the proper steps to move forward. I'm trying to open up business. So it's not, with that, I know that I have to do the proper things to make that happen.
Additionally, I would like to clarify two things. One, as you mentioned, there are no police records of
Nothing
any
that,
kind
man.
of
It's-
police
I
activity
told you my
violation.
situation, the whole thing.
Correct,
Like,
and I did follow up with that, and there is nothing there. Additionally, as of just before this meeting, your food truck was parked on the street, and that is a violation, so that is,
That truck been there for months and it hasn't moved.
it is a health department violation, so that's one that you'll need to take care of as well.
Yeah, I move it, but they never said nothing. The truck just been sitting there. The truck haven't been moved in like months.
So here's what I would like to do. So our next meeting is on the 14th of June. Is that correct?
We do not have any items for that meeting at this time.
Okay, so the 28th,
Yes.
and what's that agenda look like?
We have quite a few items for that meeting.
Okay. How does the commission feel about granting a continuance until the 28th, even though we know that there are some things on that? Because I would think that this should be a fairly simple thing to wrap up with a report from the health department as to where they stand in compliance on everything. Because if we do it tonight, I would vote no, but I want to give the applicant a time to correct the issues and to get back in good standing with the city before we approve something else.
I would support that, and I think it's the right thing to do, to give you some time.
Thank y'all.
But
Thank y'all.
the issues are serious and do need to be resolved with the health department, and I think even if we have a full agenda, we should be able to handle this fairly expeditiously.
I would agree, and I'm not going to be at that meeting, just as an FYI. I also would suggest that before we totally continue with this item, we should go through the staff review and their recommended conditions, which are in the memo, which I think you've gotten, just to make sure you're clear and there's no confusion about those.
Yeah, I don't know that we need to go through them, but I would just say to make sure that staff has provided those to the applicant, the 15 things that are listed under staff review. So with that, I will ask if there is a motion to grant a continuance of this case until June 28th, at which time we would get an update on the status from the health department on this particular property, and then conclude the hearing on this particular matter.
Clarification, would it be beneficial to have a member of the health department at the meeting?
It would be very nice to have somebody here.
Okay.
Again, I can't do that. So if somebody, if you ask and someone is able to, that would be great, because they can answer questions from us then. So with that, is there a motion as requested?
I'll move to grant a continuance to the request for a special use snack shop type 2 restaurant at 1806 to 1808 Dempster Street. That is 23Z MJV-0028, and that would be continued to June 28th meeting of the Land Use Commission.
I'll second.
It's been moved and seconded, moved by Commissioner Westerberg, seconded by Lindwall. Is there any further discussion? I'm just going to do a voice vote on this one.
Sure.
All those in favor, please say aye.
Aye.
Any opposed? With 6 votes in favor, the matter is continued until our June 28th. So please work with staff and figure out what you can do to get things in order, and hopefully then we can have a discussion to recommend approval for this.
I thank all of y'all for even taking the time to listen. It's been hard. But thank y'all.
All right, thank you, Mr. Dean. With that, we will move on to the third matter on our agenda, which is our omnibus text amendment package. As many of you will recall, several months ago, I made a referral to staff to look into some of the issues that we have that are kind of ongoing issues with the text in the zoning ordinance. There were a total of 11 things that I had put forward, and then a 12th one was added at the request of Commissioner Miranchev. So I'm going to turn it over to staff and let you kind of introduce this to us.
Thank you. I will read through all 12 text amendments to read it into the record, and then we can go through one by one. A city-initiated text amendment to the zoning ordinance, Title VI of the City Code, for an omnibus text amendment package relating to the following. 1, amend the definition and applicability of unified comprehensive sign plans and establish a review process with the Land Use Commission as the final determining body, Chapters 3 and 19. 2, modify eligible major and minor variations related to signs and establish standards for approval for major and minor variations related to signs, Chapters 3 and 19. Amend the TOD, Transit-Oriented Development Area, definition to encompass a consistent and predictable distance from mass transit lines, Section 618.3. 4, clarify language and procedures for continuance requests to public hearings, Chapter 3. 5, modify the unique use process into a unique adaptive use process that is eligible to historic and non-historic properties, Sections 637 and 618.3. 6, clarify language that prohibits curb cuts to the street when alley access is present in residential districts, Chapter 8. 7, clarify accessory structure required setbacks and yards in non-residential districts, Section 646. 8, clarify open parking required setbacks and yards also apply to loading berths, Section 646 and Chapter 16. 9, clarify definitions, yards, and setbacks for patios and terraces, Section 618.3 and Section 646. Number 10, establish a mixed-use market as an eligible principal use in non-residential and non-university districts, Title 6, Section 618.3. Number 11, modify the existing apartment hotel use and/or definition for clarity, Section 618.3, Section 688, and Section 611.4. And number 12, clarify and modify the process for adjustments to development plans for planned developments, Section 63612. The Land Use Commission makes a recommendation to the City Council, the determining body for this case, in accordance with Zoning Code Section 6345. With that,
Why don't we go through and take some of the simple ones? So I'll just pick out some of the simple ones and we'll just cross them off early before we have to have any discussion. So I'm going to start with number 12, which is the adjustments for planned developments. This is something that we actually already had made a recommendation to city council on. This was in regard to the Ann Rainey apartment issue that we also then dealt with for North Light when they had to make changes. And so this was changing things so that if it was a site allowance that we were that we would be in the position to grant, and it had to change, it would come back to us. But if it was something that did not require something that somebody normally would not come to us for at the very beginning, it was something that would not come back to us. Obviously, all of these, any changes to any plan developments would go through staff and would require some sort of staff level. So it's not like somebody just gets to decide they're going to do something. But this was in response to the fact that we noticed that you could move a building on the property and you didn't have to come to us, but if you wanted to change windows, you did have to come to us. So it was didn't make a lot of sense. So we were trying to make some sense of this. So this is basically timed out because anything that we take action on only has 90 days for city council to act on. They did not act on it, and so we're just looping this right back in. Number 11, are any questions about number 12?
So I'm sorry, an example then of what would come to us versus what would not come?
So somebody wants to change the parking. Somebody's making a change in their parking. Somebody's changing the height of their building, the FAR of their building, any of those sorts of things that we normally would look at
That would
for
come back to
plan
us.
development. If they wanted to change any of those things, whether it was something that we originally heard or not, it would have to come back to us for a change. Things that would not be covered in that are things that people normally would not have to come to us for. Plan developments are a little weird because you kind of have to come for
Right.
pretty much everything. But the point that we were looking at there was a change in materials on the facade and whether that could be handled at the staff level as opposed to having to come back to us. So that was the discussion we had at that time.
All right. So is there sort of a list of what would and would not, or again, it just depends on what type of plan development it originally was and what we would have covered at that point in time?
There wasn't a list of what was and what wasn't, but it's the things that we normally would be looking at as site development allowances.
All right. Because we do sometimes look at the exterior design.
Yes, we do, and we should when we're doing a whole project. But the thing is, literally, if somebody wanted to change one thing on their facade that may be a very minor thing, they would currently be required to come back to us, which when you're doing a project downtown, for the notifications, for the fees, everything else, it really becomes expensive to change the material on the windows or something like this.
Okay, understood. Thank you.
So that's why that one, and like I said, we passed that one, I don't remember when we did that, but it was it October? Okay. So that one is that. Number 11, modify the existing apartment hotel use and our definition for clarity. When I had originally put this out for referral, we had talked about, currently there's a 25% minimum, but there is no maximum. So what happens, lots of the stuff responds to a particular case. So this is the case for, what is the museum? It's the old King Homes, but it's now the museum residences. And so this was in response to that, as to how do we define this. In conversations with staff, after we talked about this, we discussed, is an apartment hotel even a definition that we need to have existing? Do these things exist in the way that they used to exist? And so I'm perfectly content to just remove this definition altogether. And a hotel becomes a hotel, apartments are apartments, and there really is not too many things that are going to be in between. Commissioner Lindwall?
Yeah, I mean, I don't disagree with that. I think I only disagree in terms of timing. I think it's bad precedent to be changing definitions when you've got a case that is still before the city.
This case would not be affected at all by
Well,
this.
no, I know that technically it wouldn't, but I think perceptually it would. And you know, going back to the original 1921 zoning ordinance, there were a couple of occasions when the city council decided they didn't want to do, you know, they wanted to change the zoning kind of after the fact and were taken to court and, you know, lost. You know, I think that all of our residential definitions need to be looked at, and I'm just wondering whether or not that might be something more appropriate to do as part of the whole zoning rewrite. But I agree that it's not necessary, and I understand that, you know, that particular project could be approved either based on the existing apartment hotel, you know, recommendation, or quite frankly, that site could be easily rezoned to a different D district, at which point it would be a permitted use. So that's my thought.
I mean, I would just say that almost everything we do, that we recommend approval in terms of changing text amendments is in response to something. You know, so,
I'm just suggesting that there are a lot of residential, you know, we should be looking at residential, you know, building definitions so we have kind of a, you know, I think we should be looking at those comprehensively rather than
well, and we
piece by
will,
piece.
and we will. But the thing is, we're in a situation now where is this something that we just want to allow people to open hotels under the guise of an apartment hotel in any residential district? Or do we, now that we know that this is a possibility, is it something that we want to stop from happening?
Okay.
And I would prefer to stop it from happening as opposed to, you know, waiting for it to happen again. Number 10, Ms. Klotz, I'm going to let you, since I'm kind of moving backwards here. Actually, let me take a quick look here and see if there's any other real quick ones. I'm going to go up to number 3, the transit-oriented development distance. This is just kind of making things consistent across the board. We had different distances for different things in different places. So rather than doing all of that, just making it one. If you're in a transit-oriented development, it's a quarter mile, regardless of what else is happening around you.
No, it's an eighth of a mile and
all
a
right.
quarter of a mile.
Yeah.
And I don't have an issue with this, but I do think that at some point, kind of as the comprehensive plan and the zoning ordinance, we ought to be looking at bus routes and whether or not transit, you know, those,
Yep.
the bus stops constitute a transit-oriented development. This, you know, this is implying transit station rather than, you know, so it's the CTA and the Metro rather than the other.
I don't think staff disagrees with you. However, just recognizing the purpose of the omnibus text amendment is really to address, you know, conflicts in our code. To go and add additional, you know, go above and beyond our current practice is not really the purpose of this package that you're reviewing
No,
today.
and I understand that.
But I agree with you,
I'm
and I
just
think-
suggesting that as we move forward with the comprehensive plan, we ought to be looking at that.
Okay. Number 4, clarifying language and procedures for continuance requests. This is one of those things where we've realized there's some may-shall contradictions. And so we are seeking to have those clarified so that we may grant continuances and we are never bound to grant a continuance. So that one is a pretty straightforward issue. And then, Ms. Klotz, I'll just kind of let you jump in and run through some of the rest of these, because starting up at the top, 1 and 2 kind of go hand in hand on cleaning up our signage.
For items 1 and 2, I'm going to defer to Katie as our sign expert.
Thank you. So for item 1, but as Melissa mentioned and Chair Rogers, we have encountered several instances when applying the sign code, now that it's in the zoning ordinance, where it makes it difficult to approve signs that may otherwise make sense. And also recognizing that since the elimination of the sign variance procedure from the building title. When there was the initial move of the sign code as a whole into the zoning title, Title 6. The procedure for sign variances then deferred most of them to this body as the determining body. And we did not, the standards that this body was evaluating sign variations against was not necessarily the most applicable or the best suited. So what we've done is replace the variation standards that were in Title IV when that procedure was in Title IV and the Design and Project Review Committee was the determining body, and put them back into this process. And also sign variations will be considered or processed similar to minor variations or fence variations where the zoning administrator, not the land use commission, is the determining body. So that's kind of the first procedural change. The second procedural change that is related to that, but I think the easiest way to consider the Unified Sign Plan, previously known as Unified Business Center Plan, Unified Comprehensive Sign Plan, or Sign District Plan, kind of like a plan development for signage only, I think is an easy way to think of that, where businesses are asking for sign packages for an entire property or multi-tenant property where they may need more signage than is typical. So the standards are evaluated a little bit more on the aesthetic and the character of that property and how it fits into that block area, and less about does it or does it not constitute as a unique circumstance or hardship, whereas the new sign variation process is being considered as, they have to be evaluated against, is there hardship or not? Is there a unique thing about the architecture of the building or the site layout that is warranting them putting a sign in a certain location, or them needing a bit of a larger sign than normal? So those are the two procedures that kind of come out of more or less fixing that initial relocation of the sign code into Title VI. And I think there were a couple tweaks to the variations. There's a directory sign that was in the definitions part of the sign code that is kind of defunct, and it's also content-based. So I removed that because it did refer to unified sign plans. And also for unified sign plans, you can have a primary sign. So that's intended to, if some of our strip centers have multi-tenant monument signs, that's really what that's getting at, is they can have the larger sign because they're going to have multiple tenants on it. They're not going to be allowed to have multiple monument signs in a row along one frontage. The key limiting factor from unified sign plans is also it eliminates the need for there being 4 tenants to the building. So if there's a larger property and they have a really long frontage and they want more signs, they could take the unified sign plan route and just make sure that their signs are not going to be cluttering the property. They're not going to be overly large or out of scale for the property or for the block area, but they may not necessarily constitute as a hardship or unique circumstance. It's more of a design element, and it allows this committee to kind of make sure that they're placing signs in logical locations, not just because they want as many as possible or the tallest sign possible. So that's, in a nutshell, the changes that are proposed. And I think I've mentioned this in the past, but we also, there was a Supreme Court ruling in 2014 requiring sign codes to be content neutral. So it is staff's intent to eventually rewrite the sign code, particularly the temporary and exempt sign code sections, so that you're allowing signage based on the use of the property and or the lot size and the building type, rather than giving different businesses more or less signage or free speech than other businesses. So that is a longer-term goal, but this is at least addressing the issue of administering the sign code, and it gives, it takes away from this body getting into the weeds on sign variations.
I have a question. I have a question on the directory sign definition. You know, I get it's intended for viewing while in a premises by pedestrians or those driving vehicles, and is not legible from a public right-of-way. That's the not being legible from a public right-of-way is what I'm just trying to understand what
Okay.
that's intended to mean. Does it mean that for a larger property where you have to drive in and you're looking at your industrial property, or I'm not sure. I'm not sure what that's intended to do.
It's intended to be, it's a sign that it's smaller in size. So it's not going, you're not going to be able to read it. So it's in, that type of sign is in the exempt sign section. And there are some conflicting definitions and terms. So I just wanted to clarify what that type of sign is so that people aren't going to try to say, oh, well, this is just a directory sign, and they kind of blow that regulation out of the water, but they don't have a permit and they don't need a permit, and then there's not really anything we can do about it.
No, it's
For sure.
just that it's intended for viewing while driving a vehicle, but it's not legible
So-
from
so-
the public
so
right of way. I'm just
I think of this
confused.
kind of as, like St. Francis Hospital obviously has their St. Francis Hospital marquee.
Okay.
But then they have a bunch of parking and deliveries and all those
Okay.
types of signages.
So they're more internal
that
to
are-
the site.
Are more internal or are of a lesser category, so that, yeah, you might be able to read it as you drive by, but it's not going to compete with main signage.
Mm-hmm.
It's kind of signage about enter here, deliver
Right,
here, that
okay.
sort of stuff.
Okay. I'm just wondering if there's a way of, making that point without saying it's not legible from a public right of way, because that, kind of like the enter here, you're still going to be seeing it from a public right of way.
Right.
So the current definition, where it says, which indicates the name and/or address of the occupants of a premises accommodating multiple occupants. So where it's saying that indicates the name or address, that's content-based. So this was kind of a way to still get at what is the function of the sign without prescribing what has to be on it.
Okay.
And then it will be something that's smaller. Now, there may be it may be possible that it would be illuminated. Then they need an electrical permit for that. But if it's, like 2 by 3 coming up from the ground, and it's shorter, and it's just in your parking lot island, we don't necessarily need them to apply for a permit for that, other than an electrical
Do we
permit.
want to say, and it's not easily legible? I mean, just, because, there may be instances, I just, I don't know. I'm happy to leave this as it is, and we can always revisit it if it's an issue.
You may simply add, and not intended to be legible from a
Oh,
public right.
good idea.
Does that work for staff? Okay.
Thank you.
All right. Are there any other questions on signage? And this is something that, as you recall, has kind of been given to us just recently, and we've only had one case, which was for Underwriter Laboratories. Number 5, to modify the unique use process of into a unique adaptive use. Is this one you, Ms. Klotz?
Yes, so the zoning ordinance currently features a unique use process. To my knowledge, it has been used one time for the old District 65 campus property, which was split up into a couple of single-family home properties, but then there were also some larger buildings that were, at least one of them was made into, I believe, condos, all within the R1 district where that would otherwise not be allowed. So staff is requesting to expand that opportunity so that it can apply to any property and not just a property that is already a designated landmark property. We have had a number of religious institutions as well as some other buildings reach out saying that they are trying to downsize and looking for other opportunities of how to use the building rather than tear it down. And most of these properties are located in the R1 district where there aren't many options. There aren't many uses available that could save the building. So this would be a way to meet more of our CARP goals and allow buildings that are not designated as landmarks to remain in our community.
And so when we talk about expanding that to non-historic structures, it means really structures that don't have a landmark designation. But the structure itself may have been an older building that was used, and you're going to try to adapt that, obviously, right?
Correct. A good example would be 2715 Hurd. That came forward for a plan development that did not work out. To my knowledge, the building is sitting vacant at this point.
And, sorry, one more question on this one. My only concern was you said eliminate parking requirements, noting that those sites are usually either have parking or cannot have parking because of what they were. But won't this really depend on the use? If they are turned into residential structures, there may have to be some accommodation for parking. So I'd want to make sure we wouldn't want to eliminate it completely. That would be my only recommendation.
Understandable. The intent that staff was getting at is that as a unique adaptive use, it requires special use approval anyway. So in that process, then it could be determined just what the appropriate amount of parking is, rather than having a paper number saying you need this many spaces and are requesting a variation that just, it may not look good on paper, but the appropriate level is still there.
Got it. All right. That makes sense. Thanks.
And using the special use process would allow you to consider whether or not the proposed use is appropriate in that district, because
Right,
some of them may not be.
right.
Oh, Katie.
Staff actually also watched a Chicago Metro section training today about converting office to residential. I believe that recording will be available on some various planning websites, including planning.org. So, but the tenet of that was it is okay, and it is actually becoming more common, as we've seen in Evanston, but even any way to still encourage appropriate adaptive reuse, but reduce any barriers to reusing these existing buildings, including the measures that are a part of this process, I think that's the goal of staff, and it's just timely that that was a presentation that we watched today, that it is something that moving in the right direction with market demand.
And then just a real minor point, I just was looking at the markup version at the end, and there just seems to be a little bit of consistency issue in the two, you know, the corrected definition just written out, and then what was, you know, the red line version. So not a substantive comment.
Thank you. We will confirm everything is consistent.
I have a quick question only, sorry. Is this R1 for residential one district, or this change is for all zoning districts?
The change would apply to, I believe the change would apply to
I will,
It should apply to all districts
All
because there are a number of residential districts that do not allow multifamily.
yeah,
And within the strike-through wording that we have, we are striking R1 and calling that it would be all districts.
yeah, it has to be clear that it is for all districts, yeah.
Thank you for the clarification.
All right, any other questions on that one? Number 6, on curb cuts.
This is a very simple one. We found that there is a loophole in the current code. So currently, the zoning ordinance does not allow a new curb cut to the street when alley access is present, but the way that it is written, that only applies to a front yard. When it was written, I believe we forgot that street side yards exist and that driveways potentially could go through there. So we are simply looking to close that loophole and have it also apply to street side yards so that more people do use the alley and we can keep pedestrians safe.
One small question. Are there any changes in the circular driveways?
No changes are proposed. Circular driveways are typically not allowed.
Yeah.
They're allowed in certain situations on Ridge when you also have a street frontage of at least 50 feet, I
Yes,
believe.
yes.
We're not proposing any changes currently.
So anybody else will have to come in front of us?
Correct.
Okay, thank you.
Does that apply for a corner lot where you have two streets?
If you have an alley, then you are prohibited from a new curb cut, but if you do not have an alley, you can put the driveway on the street side.
So I think in theory, if there was a corner lot that did not have an alley, if they wanted one curb cut off of one street and another one off of the other street to have a circular driveway that extended across both streets, that would meet the zoning ordinance requirements. I am doubtful it would meet public works requirements with the distance from the intersection. So I don't think it would ever actually be able to happen.
Okay.
Number 7,
Number 7 is related to accessory structure setbacks and yards in non-residential districts. This is more of a clarification. The zoning ordinance is extremely clear in residential districts on where accessory structures and uses are allowed to go and what required yards they are allowed to be in. The zoning ordinance is silent on that for non-residential districts. So the past policy has been to, in non-residential districts, that they follow the same accessory structure setbacks that, hold on one moment, that they would follow either the typical residential setbacks, which is typically 5-foot setbacks or 3-foot setbacks, unless that principal structure setback is even less. So for instance, in the downtown, there are typically 0-foot setbacks. So if you could have a, say, 20-story building at 0 feet, you should probably also be allowed to have an accessory structure at 0 feet. So that has been past policy. It is just not codified, and we would request doing so for clarification.
any questions? Number 8, clarify open parking setbacks and yards to apply to loading berths.
This is also a clarification that the zoning ordinance is just silent on, and we have had a consistent policy. The zoning ordinance specifies setbacks and yards for open parking, but does not currently say that that also applies to loading. It's logical that it would apply to loading, so we just request to add that into the zoning ordinance.
All right.
And, sorry, just to clarify, and it says here that we will require loading berths for larger developments, so that we can make sure that would be considered as part of any planned use proposal.
Yes, so we are not proposing changing the requirement for loading berths, so that would stay consistent. And then through the plan development process or any other entitlement process, they could still request variations or site development allowances for those regulations.
Okay. Number 9, clarifying definitions, yard setbacks for patios and terraces.
This is a much-needed clarification that was requested by Commissioner Miranchev. Staff has had a hard time with this one, and what we have ultimately come to determine is that the zoning ordinance conflicted with itself a little bit and had some definitions sort of reversed. So we are trying to be logical here and establish what a patio really is and what a terrace really is. And essentially what we have come to is there is no need to regulate terraces at grade because they are effectively a front porch at that point if they're in the front, or a patio if they're not in the front. So we are trying to simplify this to be clear that patios are only allowed in rear yards and they have a clear definition now, and a terrace is essentially a porch.
How about a roof terrace?
That would be a roofed porch.
I'm sorry to ask a question about something that I asked for, but did you clarify, one of the things that I meet in my, let's say, everyday practice is that sometimes people have very wide lots, but patios are not allowed in side setback. It's not in required side setback. It's in any side setback. I thought that we can be a little bit not so strict for that. I don't know if you agree with that or not.
Staff did consider that because we do find it logical to allow a patio in a side yard when you have quite a bit of space and you're not in your required side yard, that last 5 feet. Ultimately, that because of the way the zoning ordinance is written, that expands to become a significant text amendment. There are multiple code sections that state no accessory structure or use that is detached from the principal structure should be between the principal structure and the side setback. And so by adjusting that one logical regulation, we are opening a can of worms to all other accessory uses and what should we do. So ultimately, we determined it's probably best to leave that for our new zoning ordinance that will fix the entire thing.
And I would think that properties that could accommodate a patio in the side yard are not a large number of them in Evanston.
Yeah, I know.
I mean, there are some.
It's a conflict, I know, because we had in the zoning board, we had this problem, and there was a problem with the neighbors and with the noise.
Right.
That's why we didn't allow it then. And I know this is a problem, but sometimes even I received the consent of the neighbor in a large, and it's a attached patio to the house, and it's still not allowed. So this is a kind of a thing that it happened to me, that's why I'm asking. But anyway, I would agree that it probably requires a little bit more work on all the accessory uses, because I found many other things in the accessory uses, but they don't deserve attention right now. They're very specific cases. Thank you.
No, I have a question on the terrace definition. Isn't a terrace on a structure above grade? So if you have if you have a property, you have a second floor, and you have an area that you want to put a porch, but it's not really a porch, not on the second floor, would it be considered a terrace?
It would effectively be a deck, which actually has a little bit of more ability of where it could be located on the property, because a deck, when attached, can be in a side yard.
And that's why I'm asking, because if now that deck is now on the second floor, I mean, the definition of a terrace itself is an open area, elevated. It's an elevated open area.
If it were moderately elevated, it would be treated the same as a deck, and I believe it would meet the definition for a deck. If it was, say, like on a second story where it's like it's acting as the rooftop for it, then it would follow principal structure setbacks for the building that's underneath it anyway. So that would be allowed then.
Okay.
It would also have, if people can stand under it, it would get the building lot coverage applied to it too, instead of the exemption from the impervious surface, because you're able to stand under it and use the space under it. So that's how we have reviewed those when we get permits like that.
Similar to an elevated deck.
Okay.
All right. And I think number 10 is the last one.
Number 10 is not a clarification. This is a new request. Staff requests establishing a new use called a mixed-use market. This would basically encompass a number of uses or sub-uses all within one building or location. It could all be operated by one entity or multiple entities altogether, but this is a newer type of use that is doing very well in larger communities and communities that have some larger buildings, say old industrial buildings that are now in some bustling commercial districts and really should have more uses for the more active uses that the community can visit and patronize. So this type of use ends up helping small businesses, pop-ups, economic development, that type of thing. But unfortunately, zoning becomes an issue for it, because if we look at every single individual use, there are always some that just won't comply with the underlying zoning district, or they are these unique new business types that don't exist within our zoning ordinance, or a special use is required for that sub-use that is actually one person operating a 20 square foot area, that type of thing. So we are requesting making this an overall use that has a little bit of flexibility with regulations based on what zoning district they're in, specifically more flexibility within the downtown, and then a moderate amount of flexibility in the neighborhood business and commercial districts, but noting that we have had requests for this, and the way the zoning ordinance is currently written, they end up going through the zoning process quite strangely, to be honest. And we've had a couple play out in recent years with the zoning board where we had one property on Green Bay Road that had to consistently come back for special uses as more of those little sub-uses were added to the building. And then we had another property on, I believe, Washington, where one of the, I believe, 7 uses triggered a special use, but in reality, the board was reviewing the entire proposal as a whole. So it makes more sense to provide that small amount of flexibility when it's a smaller use, but then keep the special use requirement or an administrative use requirement when it is moderately sized, so that we can look at the entire facility as a whole and determine whether or not it's appropriate.
Yes.
I have a question. I was looking at the table with the, the permitted special uses on page 12, I guess. And I'm wondering if, just for clarification on the middle one, you want to say mixed-use market more than 7,500 square feet and less than 20,000 square feet, just for clarity. And then the other question I've got, you've got it listed, the ones for more than 20,000 square feet listed as a special use in the D districts. My question becomes, what if what about the locations where we have big box spaces like Home Depot or, we still have Best Buy, I think. But now some of them are in, like Best Buy is, well, no, actually, they're both pretty much freestanding. I can understand a shopping center being able to subdivide big spaces, but should we be considering those and I don't know if we have any big industrial spaces that would exceed 20,000 square feet, but those are the kind of spaces that you might want incubator or something. And
Most of the big box stores are located in the C districts. On the one hand, those do typically have large parking lots and could accommodate a lot of people. But I do think it would probably be appropriate to transition the administrative review use to the special use requirement when they're hitting 20,000 square feet, since that is a fairly substantial.
no, I'm talking about including them, because right now, on the more than 20,000 square feet, you only have the special use listed in the D districts. And I'm wondering if they should also be in at least the C districts, and I don't know about any of the manufacturing districts.
I think it makes sense for the C districts, the M districts, the I districts, and the OWE to add that as a special use at 20,000 square feet.
Could we put that in as a special just across the board?
I don't know that you'd want it in the O1 district, would we?
It's already a special use in the O1 as proposed. It hits the special use when it hit
Oh,
at
okay.
7,500 square feet. So effectively, and
But if we
everything would have.
but if we change the tag on there as 7,500 to 20,000,
But we
Then-
still have bigger buildings.
then
more
we
than
need to
20.
change the special use across the board as well. You follow me? So in the column down the left, right now where it reads anything over 7,500 square feet becomes special use. Well, obviously, something over 20,000 square feet is a special use as well. But if we change that to say 7,500 to 20,000 square feet, then we need to clarify that for anything over 20,000 square feet, it would also be a special use. So it's just cleaning up the chart.
Understood.
Well, I think it's, if we have, if it seems that we're dealing with anything over 20,000 square feet differently. And so it is cleaning up the chart, but it's also making sure that special, those larger buildings in those districts could take advantage of
Yeah,
this
it's just that since
Yeah.
we're changing that language on the left, that
Yes.
changes where things need to be in the chart. Any other questions about,
Just one clarification. You said on page 13 that uses within that mixed-use model would be expected to really self-regulate. So if there's a use that just doesn't fit well with the others, the overall operation will probably understand that and address it. However, it may take some time for them to do so. There may be some impact on the neighborhood, so I'm just curious if there are some uses that we might want to limit in certain areas. I know that's difficult to do if you're thinking of with the mixed-use model, but, you don't want an auto body shop probably operating right next to a food shop or a stationery store or a yoga studio, whatever.
It's a good point. I don't have a great solution for it other than, as proposed, this would only be a permitted use in a few instances and typically at less than that 7,500 square foot cutoff. So it is unlikely to happen. It doesn't mean it couldn't happen, but unlikely. And for instance, an auto repair use, then what other businesses would want to co-locate with it? That's what we're getting at with the self-regulating portion.
And I can understand that. I'm just wondering if there might need to be a little more oversight at times, and I don't know how you provide for that. I don't have a solution for you either. But it might be helpful to provide for some oversight, and I don't know whether that would be based on the square footage or the type of district it would be going into.
All right. I'm not getting an answer back, but.
I didn't mean to throw you for a loop. I'm sorry, it's just a comment.
You have very good points to make. The other thing that I would note is that within the definition of mixed-use market, we are noting that the majority of the sub-uses must be retail, restaurant, and/or service-oriented in nature, so that we are keeping that commercial feel to it. So again, that should deter some of those nuisance uses from going in there, but to your point, in theory, it could happen.
But if they become a nuisance, property standards could address any nuisance that occurs if people did not self-regulate.
Correct.
Okay. Sorry. Does anybody have any questions just overall or on any one in particular that maybe they thought about afterwards? First off, thank you to staff for putting this together quickly. This is a lot.
It was a full team effort.
So I do appreciate that. We do have some standards that we must find are met for text amendments. There are 4, and I will speak to these as a whole rather than going through each of the 12 4 times, which is the purpose of an omnibus, so that we don't have to do that. And the first one, first off, for the record, I'll note that there is no one else in the room to provide any public testimony, so
And let me just say, I'm shocked by that. Absolutely shocked.
Bureaucratic language is not a big selling point. The first standard is whether the proposed amendment is consistent with the goals, objectives, and policies of the comprehensive general plan as adopted and amended from time to time by City Council. In looking at this whole slate of things, obviously one of the things that the comprehensive plan does intend for us to do is look at such things as adaptive reuse, consistent language, which is a lot of what we're kind of doing here. In looking at like number 5 with the unique adaptive use, looking at the mixed-use market areas, those sorts of things, that kind of goes to that being able to redevelop properties that otherwise don't have a defined purpose as easily. And some of the other things, for example, unified signage and things like that, is definitely part of the comp plan in terms of overall feel of neighborhoods, and the impact of businesses on those neighborhoods and on our city streets. So I believe that standard is met. Number 2, whether the proposed amendment is compatible with the overall character of the existing development in the immediate vicinity of the subject property. Since this is kind of a citywide thing, there isn't truly a subject property. Some of these things, like I said, have been kind of in response to some things that have come before us. Others are kind of long festering issues that staff has dealt with time and time again, and some are things like, the signage moving to us and sort of having to clarify that as to how we move through with this. But I don't feel that there's anything in here that would cause character of neighborhoods to be drastically altered. because of any of these clarifications. Like we said, some of this stuff is things that have happened in practice for years, just need to be put into code. Number 3, whether the proposed amendment will have an adverse effect of the value of adjacent properties. Again, looking at this kind of holistically as a city, lots of these things that we're looking at are trying to improve conditions on properties. Things like signage, obviously just having an unregulated Wild West kind of approach to signage does more to harm property values than to make things consistent. Things like, making sure that people understand what they're doing, what's expected of them, all of that should actually help maintain property values, and we're putting things in place to help regulate that. And number 4, the adequacy of public facilities and services. Again, there's nothing really here that would be putting a strain on any of our services. Again, lots of this is language clarifications. Is everyone in agreement with my finding on standards? So with that, I will ask if there is a motion to recommend approval of the 12 issues in our omnibus text amendment package, 23 PLND 0006.
Sure. I recommend approval of text amendment 23 PLND-006 with including the modified language discussed with respect to item 1, which is just a minor clarification of the sign directory definition. And with respect to number 10, the mixed-use market, with respect to just developing some consistency on the mixed-use market, more than 20,000 square feet, where those would be allowed.
All right.
That's it.
Is there a second?
Second.
Been moved by Lindwald and seconded by Aravalo. Any further discussion? Hearing none, would you please call the roll?
Commissioner Lindwall,
Yes.
Commissioner Johnson,
Yes.
Commissioner Westerberg,
Yes.
Commissioner Miranchev,
Yes.
Commissioner Aravalo,
Yes.
Chair Rogers.
Yes. So with a vote of 6-0, the motion does carry, and the omnibus will move on to City Council with recommendation for approval of those matters. And that concludes the business that we had. Is there any communications from staff?
Yes, I have some bittersweet news to share with the Land Use Commission. So Katie Ashbaugh has put in her resignation and will be departing on June 9th. I want to thank her for all of her contributions to the city of Evanston. There are many, things like working on the Evanston Labs, Varsity Theater, the legacy plan development that just came through, several text amendments, special uses, and most recently leading the effort to develop the comprehensive plan and zoning code RFP. I can say with confidence that you're leaving the city in a better place than when you started. And on behalf of our team, the Community Development Department, the city as a whole, thank you. And I wish you the best as you leave for the city of Chicago. So if you'd like to say anything, the floor is yours.
We have 3 minutes.
Thank you all. It's been a pleasure serving all of you in this capacity, both as the Zoning Board of Appeals liaison and now trading off with Megan Jones as the Land Use Commission liaison. And it's been great working with Liz and Melissa and the rest of the Planning and Zoning Division team and in community development. And I can confidently say that without the opportunities I've had with the city of Evanston, I would not be going on further in my career where I am. So I'm just really grateful for the opportunity. It is bittersweet. I obviously was very much looking forward to working on the comprehensive plan and the zoning code with everyone, but I know that the team that we have here is going to continue it and continue moving it forward, and it's going to be an awesome project for the city. Thank you.
Thank you. And on behalf of the commissioners, I would like to also say thank you for the work that you've done in helping put together packets, get us all informed on the various projects, and being able to answer questions when we have them. So thank you, and good luck.
Thank you.
There is no public to make public comments, so at this point, I will ask if there's a motion to adjourn.
I'll motion to adjourn.
I'll second.
So it's been moved and seconded. All in favor, please say aye.
Aye.
Aye. So we stand adjourned. We will not be meeting on the 14th, so we will be meeting on the June 28th will be our next meeting here in City Council chambers. Thank you.
Chair Rogers, can I ask for 3 minutes?
Yeah, you get 3 minutes as well.
It happens to be my birthday today, so can I offer some chocolates and beverages to everyone?
I think you probably could.
With your permission, they'll be here.
All right, thank you. And happy birthday. All right, so we do stand adjourned. Thank you, everyone.